weren't in any trouble. They weren't being silenced. Their content wasn't being questioned. Their content wasn't being collected, except for a few on TikTok. I believe there were 6 that were subpoenaed and parts of their content were being asked for whatever reason. But again, they weren't in any trouble. They weren't even really being subpoenaed. It was a social media app that was being subpoenaed, and they were a part of it for basic information. Not one of those content creators needed to spend a penny on this situation. They didn't need to fight this subpoena. What is the point of fighting the subpoena when only your basic information is going to Blake Lively's legal team to help her litigation?
Hi, besties. Can you believe there's pro Blake people that speak like that on their platforms? Julie, recap with Julie. I don't have a lot to say about her because I actually had a couple arguments with her about her coverage because she's completely smearing content creators that are not even pro Baldoni. They're just reporting on the case and they don't, appreciate Blake Lively. Some people, she calls us anti-Lively, I guess. Anyway, she says it's not a big deal that Blake Lively wants our bank account numbers and our credit card numbers and IP addresses. She has all kinds of videos where she's defending these subpoenas. Yet she's from Canada and she clearly doesn't really care about it because she wasn't subpoenaed and that we're only fear mongering. And of course, why wouldn't we just want a celebrity to have our information? It wasn't even us that were being subpoenaed. It was the platforms. No, the platforms literally contacted us and told us we needed to quash it because they were going to give her our private information. Anyway, Julie, why did they withdraw the subpoenas if these were so valid? Anyway, Blake Lively got her own special forces of content creators that work for her, and I'm convinced that Julie is probably one of them. But she got a response from Wayfarer yesterday about the motion to strike. And they had some terse words for her in regards to her temper tantrum about how they leaked the deposition information to the media. And then in the letter, Ezra basically told more information about what occurred at the deposition, which Wayfarer has never even discussed. And it was interesting that Ezra would go through the entire of what happened in the deposition in her letter to correct the record. But apparently Wayfarer needed to respond to that. And they also wanted a motion to strike because apparently putting the transcript on the docket is abusive, I guess. So Kevin Fritz wrote a letter to the judge to respond to the motion to strike. And if you are wondering about what's going on with Wayfarer, I mean, Brian Friedman rarely, if ever, files anything in court anymore. In fact, he has taken such a back seat in the court filings that it's primarily Ellen Garofalo for his firm that's doing almost everything now, along with Fritz at the New York firm. So between Garofalo and Fritz, they're kind of leading things at this point. And while Friedman is the lead counsel, he does not speak to the media and he's not leaking things to the media. Blake is on her rampage against him. Anyway, this is what Kevin Fritz wrote. Miss Lively frames her argument as a motion to strike pursuant to Federal Rules of Civil Procedure 12F and the court's inherent power. However, 12F does not authorize this court to strike documents other than pleadings. Pleadings include only the complaint, the answer to cross claims, counterclaims, third-party complaints, answers to third-party complaints, and replies when ordered by the court. They do not include exhibits submitted in connection with oppositions to motions, denying motions to strike to oppositions to motions to dismiss as procedurally improper. And there he went again, citing Judge Lyman's own ruling. Kevin here actually cites 2 of Judge Lyman's rulings. It would appear that subtly Wayfarer is trying to remind Judge Lyman of his own work so that he doesn't keep, interfering in this case by going against his own rulings. So he brings up 2 cases where Judge Lyman literally denied people having things struck from the record because they weren't proper. Good job, Kev. Further, Miss Lively does not contend that that the deposition transcript contains abusive, improper, or libelous materials, which might warrant the court's exercise of its inherent power. He then goes on to cite 2 more cases out of the same court. Okay. After all, the deposition transcript records are Miss Lively's own words. Miss Lively contends that the transcript must be stricken based on her speculation that it was filed for the purpose of the transcript into the public domain as fodder for their media campaign. The transcript, however, was filed under seal, and Miss Lively has the option of moving to keep the document sealed, although it's puzzling why she seeks to conceal her own testimony in an action in which she is the plaintiff. And then there's a footnote. We are unclear why Miss Lively refers to her deposition transcript as a rough draft, given that the document is not marked as rough draft, as such versions of transcripts traditionally are. Then they go on to say the deposition transcript was filed in connection with Liner, Friedman, Tiltman, and Cooley LLP's motion to quash Miss Lively's subpoena seeking Brian Friedman's purported statements to content creators and the media. Liner Friedman moved to quash the subpoena, which motion has since been largely granted. The parties fully briefed the issues, and on July 30th, 2025, the court heard oral argument. No additional argument or supplemental briefing was requested by the court. Nevertheless, Ms. Lively filed a letter with the court which purported to address certain questions with the court, but which was truly an improper submission of further argument on the motion to quash. You know, I do like that they're pointing out to the judge that her letter was completely unnecessary because absolutely nothing was required. Blake has done this repeatedly in this court where she has filed letters to offer further argument for what it is that she wants. Like, think about the Rule 11 sanctions that she wanted to remind the court about her motion to dismiss. And ultimately, the motion to dismiss was granted for litigation privilege, but she didn't need to file the sanctions motions. And to this day, that judge has not ruled on those motions for sanctions. The Wayfarer parties responded citing Miss Lively's deposition transcript, which was attached as an exhibit to demonstrate for the court that Miss Lively's allegations of an ongoing smear campaign are unsubstantiated. By improperly submitting additional arguments on the motion to quash, Miss Lively invited a response that would include evidence to establish the true reason why Miss Lively served the subpoena upon Liner Friedman. It is routine for the court to consider deposition testimony in connection with discovery disputes. And then again, he cites a ruling by Judge Lyman from October 4th of 2024, citing deposition testimony in order on motion to compel discovery. Contrary to Ms. Lively's contention, the Wayfarer parties did not hope to make her defend the continued sealing of the transcript so they can advance a false narrative that she is afraid of her deposition testimony becoming public. Ms. Lively will either move to permanently seal her transcript or she will not. The choice is hers. Ms. Lively next alleges that it also appears that the Wayfarer dependents immediately leaked details from the deposition to tabloid media. She does not cite any evidence. This is not surprising, as there is none. Ms. Lively also fails to explain why any such leak could not have been or originated from Ms. Lively, her husband, her multiple attorneys, legal or administration staff, from the law firm representing her, whose office she demanded host the deposition, or the catering staff employed thereby who served lunch. Putting aside the identity of the culprit, the identities of those in attendance for her deposition are not newsworthy because all parties are entitled to attend all depositions. For the reasons set forth above, the motion should be denied. You know, I did think it was really strange the way that that leaked, getting back to his last point about her allegations about, you know, they must have leaked information about this deposition. When it came out, I thought, what a non-story. It is. It's an absolute non-story. They were acting like Justin was doing something wrong by being there. And the headline was more like, they're going head to head. They're going to face off. That's not how depositions work. I mean, when you're in a deposition and you're not the party being deposed, you don't get to say anything. So if the entire Wayfarer defendants went, and it is their right to be there, by the way, they don't say anything while being disposed. They just watch the testimony. They are not asked questions by the counsel. They don't get to interrupt Blake Lively. The only thing they can do to help is they can observe her testimony. And because they know the story better than their lawyers, during breaks, which happen during long depositions, they can confer with their attorneys and say, okay, she said this here. You might want to ask a follow-up question here, or here is some evidence here that you didn't think about, or here's another question you could answer here. The goal is to ensure that all of the questions that they need for their discovery purposes and the testimony that they're seeking from her for the evidence that they're looking for is asked. Because attorneys are not always thinking about all the details because they don't know every detail. They weren't there. And so you're there to help your attorneys and help your own case and help your own defense. It wasn't abusive for them to be there. And there are so many people there. It is true. Any one of those people could have contacted TMZ. To assume that it's someone from Wayfarer is ridiculous. And because articles were made mocking her on Daily Mail, why do they naturally assume it's Wayfarer? I mean, you do realize that Daily Mail's reporters are very well capable of mocking people without being tied to anyone. Furthermore, going back to what he said, transcripts from depositions are routinely used when discussing issues related to discovery. They can be used in motions. They can be used in motions for dismissal or motions for summary judgment. Like, now that they have her testimony under oath, they can bring up her own testimony in almost every filing if they need to defend themselves. And if she said something under oath to suggest that she didn't and was not aware of any ongoing smear campaign, and her only claim of a retaliatory smear campaign has to do with a lawsuit, that doesn't qualify as a smear campaign. I think, and I could be wrong, but Ryan Reynolds is from Canada, and Canada has some interesting laws about lawsuits and legal cases. And in Canada, you can get publication bans, meaning nothing that happens in court can actually be published to the wider media. And they have stricter laws about what can be discussed that happens in court because of like concerns about jury pool and all of those issues. And because their rules about the court are very different than ours, it almost is like he wants us to be able to apply what they can do in Canada, where they can just ban any publication of what's happening in court, meaning you can't discuss any court filing. You can't go on no records are even available to search. That was how Blake and Ryan were able to hide from the media all of their lies related to that paparazzo that they've tried to put into prison. I mean, they put a ban on publication of all of the records until the case was closed. And so for years, people just assumed that Ryan was hit by a car when he wasn't. And they assumed that he was a victim when he was actually the perpetrator. And he was allowed to lie publicly about this for years and paint himself as the victim when the victim in the case was the paparazzo that they were trying to send to prison for doing nothing. Blake and Ryan have a long history of accusing people of crimes that they don't like and falsely accusing them of crimes that they don't like to destroy them. And it started, I mean, years ago with this guy, Richard Fidek, who they falsely accused of trying to run them off the road, stalking and hitting him with a car, which he did not do. And then when the files were opened and they were able to be seen by the wider public and Richard started putting them out and he shared them with me, it was clear that Ryan and Blake were lying. So it's almost like Ryan wants to force the courts here to act like Canada and ban publication. And because in Canada, you can ban publication and claim that, talking about a court case is smearing. It's not. In the United States of America, which he is now a citizen of, anything that happens in public court is for public conversation, especially with public figures. He wants the benefit of the privacy that's afforded to them in Canada, but he wants also the benefits of being a United States citizen. And to me, it's like, Ryan, you are here in the United States. You are using our courts. You are using our tax money. And in the court here and in the United States, we are founded on a basic principle of freedom of speech, which means all of us have a right to speak about public documents and public figures, regardless of anything. The only thing that doesn't cover it is defamation, but defamation is not happening here. No one is defaming you. And even with these quote unquote smear campaigns, you are not even claiming defamation occurred with content creators. You're not even claiming you're trying to claim that Wayfarer is defaming you through their attorney, but you haven't stated anything that the Wayfarer parties have actually said that was defamatory, because you can't. There's nothing defamatory. And even within this quote unquote smear campaign, you still can't prove that anything there was defamatory, because how is it defamatory that a video of Blake saying her own words and people responding to what Blake says, a smear campaign? That's literally people just responding to what Blake said. A lot of this comes down to control for me, and a lot of it comes down to, if Blake Lively is so confident in her testimony, she should have absolutely no problem with her deposition being public. I was involved, and I'm currently involved in a case with Robert Shin, who is under investigation for sex trafficking in California and federally. And he sealed his deposition transcripts, and he wanted everything to be attorney's eyes only, which is a lot what Blake and Ryan are doing. And he's the plaintiff in that case too. And I kind of agree with Wayfarer's, like, if you're the plaintiff in a case, why are you afraid, or why do you care if your deposition and your testimony is public? Because if you go to court and if you go to trial, your testimony will have to be public. And no one is saying that Blake is fearful of it being public, but why are you having such a reaction to this being filed into court? Because once you took your deposition, anything you said could be used in future filings. And that's a part and a consequence of filing litigation and participating in a deposition. No one is saying she's afraid for it to be public. It's just, if you want it to be sealed, Blake, all you have to do is ask for it to continue to be sealed. And the judge already said he would continue sealing it, and you wouldn't have to fight the sealing. So it just kind of just felt like another filing for her to smear Wayfarer and make them look like they're stalking her and they have all of these agendas that they don't. So Wayfarer was also granted an extension for their response to Blake Lively's 2,000 pages of a motion to compel. And so they have until Monday of next week to respond to her demands for all of the documents that she claims they have not provided to her. And, they are withholding from her. And, she's already set the stage with her filing to Perez Hilton that she's not going to get the documents she needs because, naturally, what? Because Wayfarer destroyed evidence, because they've already got their scapegoat. And then finally, to Julie, just to remind you, it's not basic information when people want your bank account number or your credit card information. That's not basic. All right, y'all. So tell me what your thoughts are in the comments below. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed, and click the bell so you never miss a video. Thanks so much for watching. Bye, besties.